International Law and Corporate Participation in Times of Armed Conflict by Kevin Crowe in the Berkeley Journal of International Law. The question, when can a corporation be held financially liable under international investment law for participating in mass atrocities? Under the status quo, states answer for human rights violations, and natural persons answer at criminal tribunals, but corporations are financially liable to no one in international law. The article's premise, a system that gives legal persons a financial reason to limit their participation in state-sanctioned violence, would be preferable. The vehicle for exploring one, the 2016 ISDS Award in Urbaser versus Argentina. Urbaser sketched a spectrum of three corporate obligations. First, an obligation not to aim at destroying human rights. Second, an obligation to perform, mirroring state duties, as with the human right to water. And third, an obligation to abstain from violating just cogence norms, one of immediate application, binding even private parties directly. Because corporate subjectivity remains opaque, Urbaser invites boundary crossings, importing liability doctrines from international criminal law into investment arbitration. Chief among them, aiding and abetting, joint criminal enterprise, and mens rea standards built on knowledge rather than intent. Three hypotheticals test how far these tools can reach. First, Monsanto in Vietnam. The U.S. government set the specifications for Agent Orange and commissioned its manufacture. Monsanto neither designed its use nor tested its dangers. Production alone cannot breach the obligation to abstain. Otherwise, every bullet manufacturer would violate just cogence. With criminal law's tighter test, liability would attach only if Monsanto knew the chemical would likely harm humans and knew how the state was likely to use it. Second, the Reich Group in Nazi Germany. From 1938, insurers were told that the new Germany had no civil disturbances. They stopped covering unrest and denied Jewish businesses claims at home and in neighboring states. The lesson: corporations may simply go along with state-sanctioned violence when law offers no incentive to resist. Third, Northrop Grumman in Afghanistan, accepting drone navigation contracts in full knowledge of past civilian casualties. Under the public knowledge standard from Prosecutor versus Charles Taylor, accepting the likelihood of future harm can be enough to aid and abet. But applied here, that standard produces extreme results. No company could contract with any military that had already killed civilians. The conclusion is sober. Even importing criminal law's most permissive doctrines, holding corporations financially liable for crimes against humanity under investment law, is almost impossible. The deeper point is about design. International legal subjectivity shields corporations, leaving no incentive to limit involvement in atrocity. Urbaser still matters. It opens the boundary crossings, and it points toward a self-defining standard. The corporation's functions determine the scope of its international subjectivity. International Law and Corporate Participation in Times of Armed Conflict. Kevin Crowe, Berkeley Journal of International Law, 2019.